Thanks everybody for joining us. I can't believe that it's 6 months since we did the last session and the subsidy control regime is now in force. Yay! So on this next slide, please, I've set out the topics that I'm going to talk about. I thought it would be useful just to give a refresher on the Subsidy Control Act 2022 and how it works. And then the focus of today is really on the Streamlined scheme for research, development and innovation, which is relatively new and which is going to be for HE clients, the sort of the key pillar really in deciding whether or not you've got a subsidy compliant scheme. Then I thought it would be useful to give some observations about how the Act is working in practice and talk about the roles of the Subsidy Advice Unit of the CMA and the Competition Appeals Tribunal. Next slide, please. So the aim of this Act is to introduce a much more permissive and flexible subsidies regime. So you, under state aid law, subsidies prohibited. With the Act, you don't get that automatic prohibition. If you have a subsidy, then you have to, there are a number of ways of dealing with it. There are some exceptions to the principle about no automatic prohibition that you just need to be aware of. So some subsidies, for example, unlimited guarantees are automatically prohibited and others are conditional. For example, subsidies on relocation or subsidies to ailing or insolvent enterprises may need digging down a bit. So broadly, a lot of the principles of state aid have been carried across into the Act, but we have got changes in terminology. So I talked about what you do when you've got a subsidy. There are essentially three routes that you need to consider. Either if you've got a subsidy, whether you can get it within the new de minimis regime, which is called the minimum financial assistance, unlikely to be very useful for universities because although the threshold is increased to 315,000, it's still relatively low. The streamlined routes offer you a much quicker way of getting exemption, or you need to carry out a self-assessment against the subsidy control principles. The 7 principles, and look at the legal, commercial and economic effect of the subsidy. Then on the next slide, please, Romany. However, you just need to be aware that for high value subsidies, there's a system of mandatory or discretionary referral to the CMA for review. So these are subsidies or schemes of importance or subsidies or schemes of particular importance. And where there is a subsidy to a particular enterprise of more than 10 million, and that might be cumulatively or one large sum, that triggers mandatory referral to the CMA for review before that subsidy can actually be implemented. And we'll look at the role of the CMA a bit later on. So the notification system that has been introduced under the Act is really important, and it's important for universities and HEIs to make sure that if you are in receipt of a subsidy, that a notification is made because it protects you. It starts the time limitation period for challenges to be brought. Remedies are by way of judicial review, and they are enforced through the Competition Appeal Tribunal. Now, one of the things that is coming through in the Act is that there has been a shift in responsibility for compliance. So previously, the main risk to under the subsidy or under the rules for state aid or subsidy was to the beneficiary if you're in receipt of an illegal subsidy because of the risk of clawback or challenge. Now, the risk still remains the same, but actually the checks for ensuring that the subsidy is permitted is supposed to lie with the granting authority. In practice, it's going to be a combination of both, but we're seeing granting authorities taking a bit more responsibility for carrying out subsidy assessments. So on the next slide, I thought it would be helpful just to talk about the legal framework. So the Act came into force on the 4th of January 2023, so it's been in force for 4 months now. The statutory, I think when I talked last time, the statutory guidance had been published in draft, but it hadn't actually been finalised. That is now been finalised. It's quite a lengthy document. It's 160 pages long. The streamlined schemes finally were introduced on the 9th of January this year, and there are 3 streamlined schemes. So we're going to look at the streamlined schemes for research, development and innovation today. There are also ones for energy and local growth. Now, just a word about the transitional rules. Although the Act is in force from the 4th of January, there are still lots of subsidies which are being treated and assessed under the interim subsidy control regime under the Trade and Cooperation Agreement, and also for some schemes, for example, ERDF, where they're still running on under the old EU state aid rules. So, and the rules do have differences. And so it's really important when you're looking at the subsidy to make sure you know which jurisdiction it's being assessed under. I've had a quick look at the delegate list, and I'm not sure that there is anybody from Northern Ireland, but just to flag that anybody dealing in Northern Ireland, that triggers the protocols. So often that means that EU state aid rules apply. So I just thought it would be useful just to give a reminder of the 4 elements that constitute a subsidy. So the definition of a subsidy is on the next slide. Brilliant, thank you. So in order to be a subsidy, the measure must, or financial assistance must satisfy 4 conditions. So it must derive directly or indirectly from public resources. It must confer an economic advantage which specifically favours an enterprise, and there must be an actual potential impact either upon competition or investment in the UK. So that means that if you've got an impact on trade in different regions, then that can trigger the subsidy rules, or trade or investment between the UK and a country outside of the UK. Now, for universities and research organisations and HEIs, the key element of the definition of a subsidy is whether you are acting as an enterprise or a commercial organisation. And a lot of times you're not going to be, and so that means that you fall outside the scope of the rules. But I just wanted to explore that in a bit more detail. So on the next slide, I've set out some of the circumstances when universities and HEIs will fall outside the scope of the activity. So for a lot of the purposes, you'll be carrying out non-economic activities, and we're going to look at the statutory guidance in a minute. If you can evidence that you're carrying out a transaction on market terms, for example, in relation to loans, then that also falls outside the scope of the rules because there's no advantage being derived. The point that I would make about relying on market terms is that there needs to be clear evidence as to what the market terms are. So under the Subsidy Control Act, there is also an exemption for large cross-border and international projects. For example, Horizon. For those of you that are participating in Horizon projects, the subsidy control element should already be dealt with at an EU level, and so that should fall outside the scope of the Act. For where you've had subsidies or state aid that have relied upon GBA, the General Block Exemption regulation under the state aid rules, and those schemes or projects are ongoing, then under the Legacy and Withdrawal Act provisions, they will continue to apply. Now, minimum financial assistance is, in a way, it doesn't fall outside the scope, but it is a form of exemption. So on the next slide, treatment of research and development, and when research, development and innovation is treated as a non-economic activity. Now, we've been waiting for some time for clear guidance from the CMA and the Cabinet Office on what this means. There is only a couple of pages in the statutory guidance, and it's helpful in that actually in the final form, it does appear to be consistent with the approach that we've adopted recently. So it's clear that where you're carrying out education and open access teaching, publishing data and research, those and independent and collaborative research, those are clearly non-economic activities. The guidance have also said that where a university is carrying out ancillary economic activities, then it can be treated as outside the scope of the rules. And the guidance, the latest form of the guidance, has been helpful in that it's adopted the 20% rule, which a lot of people were aware of under the state aid rules, so that if you can demonstrate that there is a clear separation of accounts between non and economic academic activities, and where you can demonstrate that the economic activities are less than 20%, then that should mean that the overall you fall outside the scope of the rules. Now, it's not quite clear whether that's done at a university or project level, but I think it's helpful to have some consistency. I thought it would be helpful to flag up the areas which can be problematic on the next slide, and when you need to consider whether in fact you might be caught as carrying out a commercial activity. So contract research is clearly a activity where there are other providers carrying out good contract research and maybe charging for it, so that can be treated as a commercial activity. The renting out of space, hot seats, equipment, or access to laboratories, commercialization of IPR or spinning out a company, consultancy services, I think that's one that's often forgotten, but it will be treated as a commercial activity. Conferences, workshops, where you're providing a workshop for activities which may well be covered by other, there's a market for it, and training and education for businesses or adult education. So those are the areas where the sort of subsidy flag really needs to be considered. Right, so going on to the streamlined subsidy scheme, and what does it cover? So it's in force for 5 years from a period from the 5th of January 2023. It covers universities, research organisations and commercial enterprises. And the idea of the scheme is that if you are able to demonstrate that you are in receipt of a subsidy, but it falls within the terms and conditions of the subsidy scheme, it's treated as a permitted subsidy, and so there's no need to carry out self-assessment. However, when what I wanted to flag is that when the final version of the subsidy scheme was published, it was published actually on the 9th of January, I was a bit taken aback because it was really quite different to what we were expecting from the illustrative guidance and the sort of draft versions. It is much more limited in scope than the previous illustrative guidance. And I think the streamlined subsidy scheme is going to be helpful. But what I wanted to flag up is that there are a number of gaps. Going on to the next slide, there are 3 permitted categories of research, development and innovation, which will be treated as permitted subsidies subject to various conditions. So feasibility studies, industrial research and experimental development projects. Now this is interesting because there's no mention of fundamental research. What the statutory guidance says is that where fundamental research is being carried out by a university, it will fall within the definition of non-economic activity, which makes sense. And it says that in some circumstances, fundamental research by a commercial organisation, if it's in the very early stages and there's no practical application, may also be non-economic activity, but needs to be assessed on a case-by-case basis. But it is not covered under the streamlined route. Now, the Category 3 development and innovation support was introduced as a sort of last measure. It only applies to SMEs and it covers 3 types of support. It covers innovation and advisory support. It's quite widely defined. So, for example, it covers support to SMEs for access to testing or consultancy or for costs of buying patents. Process and organisation includes, that's category 3B, includes, for example, making use of digital technologies. And then there's category 3C, which applies for SMEs who want support in buying equipment and instruments. So you can see that it probably is going to be of most use where you're acting in collaboration or in partnership on a project with commercial organisations, and you're looking to ensure that you're not flowing down subsidies to those organisations. Now, I mentioned the conditions earlier, and on the next slide, we've got some of the conditions. So some of these will be familiar to you because they apply the same principles that were applicable under GBA. So you've got the principle of accumulation. So you have to, in deciding whether or not you can receive a subsidy, there are levels on the maximum amount of subsidies that you can receive and intensities. And in calculating those, you have to accumulate all the grant that has been received on a particular project for a particular enterprise. Importantly, the first condition is the requirement to carry out activity and exploit results in the UK. And that is going to be a common theme of many of the subsidy schemes that are now coming through from Innovate and UKRI and HEIs. Okay, so I mentioned earlier on about the scope being a bit more limited to that which you expected. And on the next slide, please, I've highlighted some of the gaps. So interestingly, the guidance that was issued with the Streamlined route make clear that it's not intended to replace the state aid general block exemption. And the coverage is much narrower. So for example, it doesn't cover fundamental research. You haven't got the equivalent of Article 25 of GBA, which relates to research infrastructures. So there have been a number of times where I've been advising universities who've been wanting to invest in new infrastructures, research infrastructures, and Article 25 of GBA was very useful. Now, I think the logic that has been applied for not including research infrastructures is that generally where a university is creating a new centre, then it'll be as part of its non-commercial activities. But there may be circumstances where actually there's a bit of both. So that is not covered. And I've also mentioned innovation clusters. Innovation clusters, there's been an amendment in the final version. So there is support for SMEs claiming support under innovation clusters under the category 3, but previously operators in innovation clusters could claim support for the operation, and that is no longer available. There are also some limitations on eligible costs. So I think that coupled with the maximum amounts, which are on the next, we're going to see on the next table, and the limitations, or sorry, Romany, if we could just skip back, I haven't quite got there yet. It's going to mean that the ability to claim for equipment and land under the Streamlined scheme is severely limited, because you can only claim for land for the period of the project, and it's done on a depreciation basis. And for equipment, if there's any residual value in the equipment, that cannot be claimed for as an eligible cost. And obviously land and equipment may be some of the, along with people, but that may be some of the sort of high values of the eligible costs. So if anybody's relying on the Streamlined scheme, it's subject to the transparency requirements of amounts of grant over 100,000. So you can see that that is quite easily met. So going on to the next slide, what I've tried to do here is set out a comparison of the permitted subsidies by value for the Streamlined route and comparing it with GBA. So if you look at the values, you can see automatically that there's a huge difference in value. So the maximum amount under Streamlined routes for research and development projects is 3 million, and that compares with 20 million under GBA for industrial research and 15 million for experimental development. The intensities are broadly the same, with the exception of experimental development, which has a starting intensity of 25%. So the way the intensities work is you have a starting point, which is 50% generally, and then there are uplifts that can be applied. So 10% for medium-sized organizations, 20% for small-sized organizations, and 15% collaboration. So up to a maximum of 85% if you've got small size enterprises and collaboration on a collaboration project. So I just wanted to make some observations about the Streamlined scheme in practice. And on the next slide, please. So it's important to note that the Streamlined scheme only applies to subsidies under the Act and doesn't apply retrospectively to subsidies under the TCA. There are a number of gaps in the coverage. So, for example, by value or by types of research, development and innovation categories. And so if you are looking at one of those gaps, it means that an individual assessment still needs to be required and you can't rely on the Streamlined scheme. I think, as mentioned, I think it's of limited application for universities as a whole, particularly in relation to research infrastructures, but I think you have to remember that this is aimed at commercial organizations, and therefore for universities, your main argument is that you're going to be relying on being in a no aid scenario. So it's going to be much easier to structure your projects on a no aid basis rather than relying on the streamlined route, except that it is useful where you've got partners with whom you're collaborating to look at the streamlined scheme. Because the limits for individual subsidies are quite low, I think there's a risk that some of the larger projects are going to be pushed into the SSOI or the subsidy schemes of importance or particular importance. And I can't remember whether I've talked about the limits and the thresholds on the earlier slide. The value is 10 million for triggering mandatory referral for a subsidy of particular importance, unless it's in a sensitive sector, which means that the threshold is lowered to 5 million. So you can see that it's quite subsidies or particular subsidy schemes can be pushed into that category. And we've talked about the importance of notification for minimizing risk. I did, in preparing for the seminar, I did a search, tried to do a search of the subsidy database at the weekend to see how many universities I could see as having published a notification under the transparency register. The only one that I could see was the University of Liverpool in relation to a Strength in Places grant a year ago. I thought it was really interesting that I couldn't find any other universities on the register. And it is important that universities check that granting authorities are making notifications, as I say, because it's from a risk potential. It means that once a subsidy is notified on the register, then there is a 1 month period in which to bring any challenge. Okay, so that's talked about the Streamlined scheme in a bit of detail. So I wanted to talk now about the case law from the CAT and the Subsidy Advice Unit. So it is relatively early stages that have come in. When I wrote the slide, there were 4 referrals to date to the CMA. They were all mandatory referrals as being subsidy schemes of particular importance, covering energy, opera house, refugee housing, and transport. I think, in fact, there are now 6 because there were a couple that I picked up yesterday. We've only had 1 actual report, which has been in relation to energy, and it is very detailed. And I'm not going to go into a great lot of detail because what the report does is to go through the assessment that's been made by the grantor authority and assess whether it assesses whether the assessment has been carried out correctly by the granting authority in carrying out the 7 principles. And in the particular referral that was carried out, the Subsidy Advice Unit didn't actually go into detail as to whether or not it went through the process, but it didn't actually give a view as to whether or not the subsidy was permissible. Where the Subsidy Advice Unit provides its report, there is a 5-day, it can make recommendations for changes, and there is a 5-day cooling off period before the granting authority can actually implement the scheme. At the moment, it's really difficult, based upon what we've seen, to see how the Subsidy Advice Unit is going to address the referrals. And I think there's been nothing yet on research. So I think there's limited information that I can provide on the reports to date. What I think we are going to see is a greater use of schemes whereby central government or local government wanting to provide a range of subsidies will do it by way of schemes where they're giving out fairly substantial sums of money, and they will need to go to the Subsidy Advice Unit to make sure that the assessment that they've taken is sufficiently detailed and takes into account the principles. So going on to the Competition Appeal Tribunal, there is a very interesting case going on at the moment, the Durham Company case. It's certainly a case to watch. Now, my understanding is that there have been a number of initial hearings. There was a case management hearing earlier this year, and the case is listed, I'm just checking my notes, it's been listed for, I believe, there it is. So the substantive decision is listed for hearing in July. Now, the reason why it's of particular interest is that the case relates to a complaint brought by a competitor, a Durham Company, against Durham County Council. So Durham County Council has set up a TECL company, and the complaint is that Durham County Council is cross-subsidising its TECL company, and it is using the resources and assets which it carries out uses for its public waste service provision, and providing them to its TECL company at lower than market rates. So you can see that where a university has set up a subsidiary company to carry out commercial activity, then it may well be relevant. So what has happened to date is that there have been a number of interim hearings. There was another complainant who tried to intervene in the case, but they were denied standing. And they were denied standing on the basis that the complainant was not actually active in the Northwest market. And so the Competition Appeal Tribunal had said that there wasn't sufficient interest to be involved in the case. I think it's also one of the other indications is that the Competition Appeals Tribunal seems to be saying, well, we are getting judicial review. We need to deal with these efficiently and as effectively as possible. So it denied standing to the additional complainant. There's also been a case relating to cost capping. And what that means, so in the procurement sphere, for example, a lot of competitors put off bringing a procurement challenge because the huge costs of a procurement challenge if it goes all the way to court. Now, in the Competition Appeal Tribunal, they have said that for subsidy control complaints, they're going to introduce cost capping so that it makes it more affordable, in inverted commas, for complainants to bring cases. So there have been a number of Competition Appeal Tribunal cases, but they relate to the TCA. So this is the Durham case is the first case on the new Subsidy Control Act, so one to watch for July. Going on to the next slide, please. So just in terms of some takeaway points from today's webinar, the Streamlined scheme is welcome because it provides a lot more certainty for universities and HEIs and research organisations about how research and innovation is going to be treated under the Subsidy Act, but it is of limited application. We haven't as yet got much guidance on the approach to assessment and the detail required for higher value subsidies, and hopefully that is going to come through once the Subsidy Advice Unit has seen more referrals and we've got more guidance from them. Anecdotally, we're seeing granting authorities take subsidy control more seriously and wanting to test opinions and views so that they're happy with that a particular scheme is not going to involve a subsidy. I think that is helpful because it means that they are actually going to be engaged and take responsibility for subsidy control rather than after something in case just passing it down the line. But yes, so it's going to be very interesting to see how this area develops in the next year or so. And I can see we've got a number of questions, so I will go into the questions and see if I can answer them. So the first question is one about the minimum financial assistance levels. So the question is, what's the level and how is it calculated? So the level is 315,000 over a 3-year period. So I think the original figure of 335,000 was the figure under the old TCA, but under the Subsidy Control Act, it's been reduced to 315,000. That's why I said it's got really important to make sure you know which jurisdiction you're looking at, because there are some differences. And the 3-year period goes, you look back 3 years in looking to see what grants have been received. So some of that will actually cover EU state aid, but that's the way that you calculate it. So there's a question about the 80-20 rule, and I think that is the difficulty. So the question is, how do you assess whether you are within the 2080 rule based on the activities, and do you look across all the activities as a whole or a particular subset in relation to a particular facility or research centre? We've never particularly had an answer to that, and I think that's an area where we would welcome guidance. Right, let's go through. Right, okay. We've had a number of instances where UKRI or Innovate UK have said they're providing funding to us under the MFA exemption. We don't think this is appropriate, and I try to push back and say there's no subsidy because we're not carrying out an economic activity, but they've been unwilling to accept this. Yeah, okay. So that's interesting. So the you're right that MFA exemption should only be used for those circumstances where you have got a subsidy which you can't permit under any other use, because once you've used your 315,000 exemption, then it's gone, and so it's really important, I think, to push back and say that you're not carrying out an economic activity, and therefore there is no aid. A couple of instances where we've been engaged with BEIS before, I think everybody is still very much in a learning phase with the Subsidy Control Act, and I think it is appropriate to push back and just test their understanding and knowledge. Now, there's a particular here about so there's a question about whether contract research can be covered under the streamlined route if it covers feasibility studies, industrial research, or experimental development. And the general answer to that is going to be yes. So that's one clear application where the streamlined rules, I think, are going to be helpful, subject of it, of course, being within all the conditions. Right. Oh, great. Thank you. Lots of questions coming in. So there's a question here about who's responsible for subsidy control. So, and who's responsible for making publications on the Transparency Register. Now, I'd be this is a question that one of you might know the answer to. So in order to make notifications on the Transparency Register, you have to be granted rights to access the Transparency Register. And I know local authorities have got those rights. The general principle is that the public authority responsible for flowing down the subsidy is responsible for the publication. And so I don't know whether any universities actually have access to the subsidy Transparency Register. And I'd be very interested to know if anybody has come across this and whether they have got access, or whether you have to refer to for BEIS or the local authority to get them to publish and to check the information that is published. So there's also a question about publication rights from a that one I'm going to follow up because I think it may be specific, and it's not easy to answer that one as a yes/no answer because it's probably case specific. Let me just check to see whether. Right. There's a question, what is the difference between SAFA and MFA? And apologies, I don't know the answer to that. I've not come across SAFA before. If anybody knows knows what SAFA is referring to, then perhaps they'd be kind enough to put it in the chat box. I hope that was helpful. I think that's all the questions that have come through and done my best to answer it. Just in terms of flagging up the next or giving some advantage notice of another webinar that is coming up in September. So the procurement bill is hopefully going to get more sent in the summer sometime, and so in the next series of this webinars I'll be presenting Beyond Procurement Act on the 19th of September. So I hope to see lots of you there as well. Many thanks.